Okay, I'm gonna start with this one, I guess. Okay, on the record, in the matter of the people of the city of Lansing, versus Michael Yates, 25-03281. Parents, please.
But we can't see anything.
You're not going to see anything. My computer is broken and they can't fix it until they can get it sent out.
Okay, thank you. Yates.
Okay, you're Michael Shane Yates.
Correct.
Okay, council appearance.
Assistant Public Defender John Lee appearing on behalf of Michael Yates.
Okay, Mr. Yates, I have here a citation. It's from October 29th, 2025 at 12:21 a.m. The allegations are that at or near the area of South Cedar in Kalamazoo, which is located in Lansing, Michigan, Ingham County, that you allegedly furnished false information to a police officer, an incident that did not involve a vehicle. You have the right to have a attorney represent you. Mr. Lee is here to represent you for the purposes of your arraignment. This is a misdemeanor. The maximum penalty is 90 days in jail and or $500 in fines. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to jury trial. And you have the right to hold your jury trial. You are presumed innocent until proven guilty, and the prosecutor, which is the city attorney, would have to prove each element beyond a reasonable doubt before you're deemed to be guilty. Do you understand those rights?
Yes, I do.
You have the right to see, hear, and question in court any witness called to testify against you, the right to call your own witnesses to testify on your behalf, and again, the right to maintain silence at trial and not have silence be used against you. Do you have any questions about those rights?
Oh, man.
Is he requesting the public defender to represent him?
Yes, he is, Your Honor.
The court will enter a plea of not guilty on your behalf. This matter is scheduled for pre-trial on November 24th at 10:30. What judge is this before?
Judge Flores.
It'll be before Judge Flores. You can appear in person or via Zoom. You should have been provided information on how to appear via Zoom. Was a CCH provided? Because I don't have it for him.
For this one.
No, not for him.
Is there a reason why a CCH wasn't provided for him? I don't understand.
And they're, sometimes when the maximum penalty isn't above 93, then they don't always give you a CCH.
Counsel, you can address bond.
Thank you, Your Honor. Mr. Yates has had some contact with the criminal justice system. It is my understanding that he currently has matters pending before the court, including a felony matter and a non-traffic misdemeanor. He does live here in the area, and he has advised me that he intends to participate in these proceedings, and we would ask the court to consider that in setting bond.
Well, they're not giving me anything to consider other than a charge. So his bond will be 500 personal recognizance. And all standard bond conditions, including appearing to court, not traveling outside the state without prior approval of the court. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to use drugs or alcohol. Those will continue. Do you have any questions about your bond at this time, Mr. Yates?
No, no, ma'am.
You're all set. Thank you. Okay, people of the state of Michigan. Virtue versus Andrew Ennis 25-02467. SM appearance, please.
Good afternoon, Your Honor. Timothy Young appearing on behalf of the defendant Andrew Ennis.
Okay, this is a matter that's before the court for a bond violation. It says here in a complaint that it's upon reasonable belief that on October 28th at 0100 hours, the defendant, Andrew Ennis, was driving a Ford Mustang while the protected party in the underlying matter was the passenger. There is a no contact order, it states here, indicating that the defendant is not to have contact or be in the presence of the protected party, Nevaeh Shisia, or Shisia, I'm not sure how you pronounce that. And so that's a bond violation, which is a contempt of court order. For your information, Mr. Ennis, you can be sentenced if found guilty of a violation to a maximum penalty of 93 days in jail or and/or up to $7,500 in fines. Do you understand that?
I do.
Okay, looks like the defendant was previously arraigned by Magistrate Milmore on a domestic violence on August 26th. And bond was set at 300 personal recognizance. He was advised that he was not to have contact directly or indirectly or via third party with Miss Shisia, and that he was supposed to provide a valid address within 24 hours of his release as to where he was going to be staying. There was a bond recommendation at the time that bond was entered. Let's see here. For a money bond with conditional release. And it looks like the magistrate deviated from that. Counsel, did you want to address the court before I address his new bond?
No, Your Honor, I would just indicate that he is currently disputing, obviously, the domestic violence charge that is scheduled for a final pretrial conference in another couple of weeks. It's our anticipated hope that that would be resolved. Clearly, there is no excuse for violating the condition of his bond. I'm not here to in any way try to justify that. He is employed. He does not want to lose his job. He has been a lifelong resident of this community. He does have a different address that he is able to provide this court if that is not already available to it. And so we would ask that the bond be continued as a PR. If it needs to be a 10%, he's willing to do that as well, just given the fact that he has clearly not understood the parameters of what he needs to be doing to satisfy the conditions of bond.
Does your client have an issue with understanding?
Well, Your Honor, I think that that's not so much understanding what he's supposed to do as much as it's there being a dispute that there was ever any domestic violence that occurred between the parties. Again, not relevant to the issue. I've made it clear to him what he has to do. He cannot be around her, can't be with her, can't talk to her, have any contact with her. And so my suspicion is that given the time between now and when this matter is resolved, they will not have any further problem abiding by the conditions of a bond that would require no contact.
I find it unlikely because if you have a blatant disregard for the bond already and you get pulled over and have the actual person you're not supposed to be in contact with in the car with you, I don't see any reason why his bond should be continued. I also don't believe he has an issue with comprehension. Whether or not he maintains his innocence has nothing to do with a valid court order. And the court order for you, Mr. Ennis, was that you were not to have contact directly or indirectly with the alleged victim. And I recognize that you are at this point, still maintaining your innocence, as you have the right to do. But there are factors that were to be considered when setting your bond, and some of those risk factors include some threats that you allegedly made to even harming of animals. It said that the defendant, of course, was in an intimate relationship with the protected party, and the crime involves violence towards another person. The people previously requested a money bond. I'm going to grant that request at this time. I'm going to reiterate that you are not to have contact. That means no communication, no phone calls, no text messages, no DMs, no letters, no messages through third parties, driving in each other's cars, no visits at each other's homes, no meetups anywhere. Do you understand that, Mr. Ennis?
I do understand.
And that court order is in place until the time that the matter is resolved. That is ultimately for the protection of the alleged victim, but it's also for your protection, because when you are seen in violation of that, you end up in handcuffs and back in jail and risking
Yes,
losing your job and your livelihood. It also could be perceived that you're engaging in activity that could be coercing the victim to not want to appear in court, which is called witness tampering. And that could lead to other charges. Do you understand that?
I do.
Your bond is now 5,010% with GPS tether. You will not to be within 2,000 feet of wherever the victim is. Did you provide the court with a valid address within 24 hours of your release as you were previously ordered?
I had called to report, and I was told that because it was a misdemeanor, I was not required to.
That we didn't ask you to call to report to pretrial services. You were ordered to provide an update to the court about where you were going to be residing within 24 hours of your release. And I don't see that you've done that, which would also be a bond violation. Where are you
Okay,
residing?
1265 Cabot Drive. I gave that address to I forget what they're called, the defendant this morning.
Defense
No.
counsel?
Yes,
The public defender you spoke, that's fine that you gave it to the public defender, but your order from the magistrate back in August was that you were
yeah,
supposed to, within 24 hours of your release, give an address to the court.
I simply had misunderstood. I thought I was
Do you
supposed
have
to
an,
report to pretrial services.
okay, I just want to make sure that you do not have an issue with understanding, because it's the second time with the second issue that I hear that you misunderstood. Do you have an
So,
issue with comprehension, sir?
no, I'm just curious as to who I would have called.
You just need to call the court, 54A District Court, and if you had questions about that, it looks like you have retained counsel, you could ask him, and he could have simply emailed the court staff with a valid address to update on your behalf. And it looks like you've appeared in court multiple times, but the paperwork, I don't know that it's been updated. Nonetheless, you are not charged with a felony, so you do not need to report to pretrial services. You're being charged with a misdemeanor. You just need to report to all of your court dates. And at this point, you need to be otherwise compliance with your bond conditions, which number one includes no contact with the victim. Do you understand that?
I do understand.
Okay. Again, bond is set at 5,010% with GPS tether. And any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
Thank you. You're all set. Now, this is the matter of the City of Lansing versus Robert Watkins, 23L2797761 OT. Appearance, please.
Assistant Public Defender John Lee, appearing on behalf of Robert Earl Watkins, Jr.
You're Robert Earl Watkins, Jr.?
Yes, ma'am.
Okay, well, you were supposed to be before me, it looks like, back on August 12th, and you didn't come. What happened?
Yes, ma'am. I ain't received nothing in the mail. I check my mail every day. I even brought mail down here to show that I check my mail every day. I never received nothing in the mail to come to court because I want
Let
to
me
get this
tell you
resolved.
something. Let me stop you. I could care less about any of you, any of this mail checking that you're doing and or proof of it, because you saw me on July 8th and I
Yes,
told
ma'am.
you the next date out of my mouth to your ears.
Yes, ma'am. They said 30
And
to 45 days, so I never
no, I told you the actual date. I told you the actual date, August
oh,
12th at 11 a.m. I told you the actual date and time.
okay,
I don't
ma'am.
just say come back in 45 days. Mr. Lee has appeared before me multiple times. Mr. Lee, do I tell the date that you need to return?
Yes, ma'am.
I told you the actual date. It's noted here in my record that I told you the actual date. This is not your first failure to appear. This is your third.
Wow, I didn't know that was my third, Your Honor. I'm
Yeah,
sorry.
yeah. Your bond is $200 cash. Your next court date's November 18th at 10:30.
Okay.
Do you have any questions?
Yes, can you say that court date one more time, Your Honor?
November 18th at 10:30. You should have received a notice from the jail. Did you get it? It should be in your hand.
Yes, I got it.
Yep,
It say
November
the
18th
it say the 10th on here at 8 o'clock.
of November.
Yes.
Judge, I think that's his other file. He has a misdemeanor too.
Yeah,
reading
you
it
have
wrong.
more than one court date, sir? In your hand?
Yes, it's 11/10/25 at 8 a.m.
What's
So
the
I got,
case number?
okay, yep, I see the other one behind it.
Yeah,
Okay, I got it.
this is for the failure to display an operator's license that you were supposed to go and get some things cleared up and then come back.
Yes, I got my license
And
and everything now.
okay, well, you never came back, so your bond on that one is gonna be $200. And you said he has another matter?
Yes.
Well, it wasn't scanned next to each other, so I don't know. Let's see, okay, no, it was, it's right here, 25-02090. Another failure to appear. He was supposed to appear on September 15th for a final pretrial.
Yes, ma'am.
I guess your excuse is that you didn't get a notice in the mail?
Yeah, I promise, ma'am, I did not. I would have been here. I didn't want to miss that trial. I wanted to get everything resolved. I promise, ma'am, I did not receive anything in the mail, and I check my mail every day.
I told you the date of your final pretrial and your jury trial.
Yeah, but I forgot, ma'am. Sorry. 'Cause
Okay, well, your bond, and let's see here, you already had a 510% bond on that, which that's interesting that you were not giving. Okay, your bond on that one will be 500 cash surety. And all your other bond conditions will continue. You have a final pretrial now on that one. That's the November 10th date. You receive both your dates right now in your hand. You will not get
yes,
anything in the mail. There will be nothing sent to you in the mail.
yes,
You
ma'am.
understand that? It
Yes,
is your
ma'am.
responsibility as a grown man to keep up with your criminal matters. You understand that? Unless you
Yes,
hire a
ma'am.
secretary, unless you hire an assistant to remind you that you have court, it's your responsibility. Do you understand that?
Yes, ma'am.
Do you have any questions about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir. State of Michigan versus Jamarquez S.T. King. This is file number 20-03434 SM. Appearance, please.
I'm trying to find the file, Your Honor. Fairly certain I had it at one point here. Ms. Straub, do you have that file? No. Assistant Public
did
Defender
someone
John
meet
Lee
with-
appearing on behalf, I believe he's already a client of ours, appearing on behalf of Jamiroquai King.
Correct, it would appear that he does have counsel, I'm just not sure who it is. I do see that he was arraigned by me, but someone put a sticky note over my date and time, so I can't see what's on there when it was scanned to me. It looks like he was supposed to appear before the court. He's supposed to be before Judge Buchanan for final pretrial on this week. It looks like October 27th. What happened, sir?
Are you asking me, Judge? Right?
Yes.
Okay, so I called way beforehand. The person that was supposed to take me, we actually was on the way there to the courthouse. The car started overheating. So I started to call beforehand, and then I called Joseph. That is my public defender. I called him, then I didn't get no call back. So I kept calling. Then the next day,
Sir, I don't know what's going on. Give me just a moment. I'm getting some feedback somewhere.
I'm sorry.
Oh, okay. My apologies. You said the car was overheating and then what happened?
I called, I tried to leave a voicemail because I called at 8 p.m. I mean, not 8 p.m., 8 a.m. when the courts probably first opened up. So I called, I tried to leave a voicemail with the court. When I see that I couldn't get through to nobody, I started calling my lawyer. I called them all day. I left them tons of voicemails beforehand, letting them know what's going on and see if I can reschedule it maybe for a later court date because I am in Kalamazoo. So it was kind of hard for me to even get the ride that I had. I ended up paying that ride still $110. We didn't even end up making it there. When I called the courthouse the next day, they let me know that I had a bench warrant out for my arrest. I tried to see if there was anything that I could do to avoid that the warrant and avoid coming here. So they said there was nothing I could do. So after work, the first thing I did was pay the last little money I had and turn myself in. Your Honor, I'm not trying to run. I'm not trying to do anything like that. It was just a mishap.
Sir, if you were supposed to be at court at 8 a.m. and there was an issue with the car, why didn't you just hop on Zoom and tell the judge that?
I didn't think about it like that, Your Honor, because they say appear in person. I should have thought about it more.
I get it, but you could have hopped on Zoom and said, "Hey, Your Honor, I'm trying to be there, but
I didn't
the
know
car,
I could
don't speak over me. The car that I'm driving in is overheating. I'm on the side of the road. And so then maybe an allowance could be made for you on your behalf. But to not appear at all, not even later that day, that puts you in a position where you're gonna get a warrant and then more likely than not get picked up. I don't know who your public defender is, or who's assigned to Judge Buchanan's courtroom, Mr. Lee.
That would be Joseph Hardy,
It's-
Your Honor.
Okay, so I don't know why they would have gotten the voicemail and maybe not related. But nonetheless, your matter is now scheduled for final pretrial. Again, you have to appear in person November 10th at 8:15. Okay?
Yes, ma'am.
I apologize that you spent $110 for someone to give you a ride from Kalamazoo, then you never even got the ride. You should have kept your $110. I can guarantee you that. But you still need to appear in person, so you need to make other arrangements. I'm going to reinstate your bond. Okay?
Thank you.
So your bond is 500 personal recognizance. You need to follow all of your other bond conditions, and you'll see Judge Buchanan on November 10th. You're all set?
Thank you, Your Honor.
You're welcome.
Your Honor, I also have on the call with this Assistant Public Defender Jessica Straub. She's probably, I think, ready to go ahead and jump in and take over the docket at this point, if that's okay with the court.
Let's Completely fine with me. It's up to you all what you handle.
Okay.
Uh,
Ms. Straub, go
okay.
ahead.
Okay, on the record in the matter of the, let's see, State of Michigan versus John Lucas. This is file number 25-022781 FY. Can I have your appearance, counsel?
Yes, Your Honor. Attorney Jessica Straub from the Ingham County Public Defender's Office on behalf of Mr. Lucas this morning for appearances for arraignment purposes. Excuse me.
Okay, Mr. Lucas is here because there was a request for violation of his bond. It stated that he was arrested in Delta Township for retail fraud and resisting obstructing an officer on or about the 27th of October, which would be in violation of his bond. What is this here? Before this court, but I don't have what that bond is. What is his bond and what is he on bond for?
And he's got a $2,000 PR bond right now.
$2,000 PR bond. What is the charge?
It's larceny in a building and then 2 counts of assault and battery.
Okay. Okay, so you have a new pending case now in Eaton County? Is that what's going on? Counsel, does he have a new case pending?
Your Honor, I am not clear. I do not have a complaint in front of me. I simply have the jails list.
Okay. Okay, well, it says he was arrested for the I should say for retail fraud and resisting obstructing. Mr. Lucas, is likely you could have a new case pending. I don't know if you've been arraigned on anything at this point. Since then, have you been arraigned, sir?
I believe so, over in Eaton County, yes.
Okay, so you have a retail fraud and a resisting and obstructing pending over there?
Apparently,
You said what?
apparently, Your Honor, yes, ma'am.
Okay, so you picking up those new cases would be a bond violation for this court because you have a pending case here. So you do have the right to have a contested hearing on the bond violation and the right to have a attorney represent you at that contested hearing. If you're found to be in violation of your bond can be revoked. You could be remanded to the custody of the jail pending the underlying case in this court. And then if you're found guilty, you also can be faced with a contempt of court order of 93 days in jail and or up to $7,500 in fines. You're presumed innocent until proven guilty in the new cases. And so we will go ahead and enter a not guilty plea as it relates to the bond violation, and we'll have it set for a hearing before the judge that is assigned to. It's going to be set for a hearing on November 20th at 9 a.m. Okay?
Yeah.
Okay, and so do you already have another pending court date in this court on that date, or is that Ms. Nash, can you tell me if he has another court date on the
Yes, he's
20th?
scheduled for a exam for you on November 20th at 9.
Okay, so we'll see you November 20th for both your exam and for your bond violations, okay, sir?
Yes, ma'am.
We'll continue your bond in 2,000 personal recognizance. You're not to engage in any assaultive or threatening behavior. You're not to pick up any new cases, okay? You can't do anything that would violate the law and put you in custody of the jail. If I get another one of these, I'm not gonna be able to continue your bond. You understand that?
Yes, ma'am.
Okay, and then you need to make sure you come back to your court dates. We'll see you on November 20th, okay?
Yes, ma'am.
Thank you.
You-
Okay, I have the State of Michigan versus Jerry Norris in file number 23-01581 FY. I have another file as well. 23 -02807, council appearances.
Yes, Your Honor. Attorney Jessica Straub from the Ingham County Public Defender's Office on behalf of Mr. Jerry Norris for purposes of arraignment.
You're Mr. Jerry Norris?
Yes, ma'am.
Okay, Mr. Norris, Mr. Norris, you were supposed to appear before the court back on July 31st, 2023. And you failed to appear. This is for stolen property, receiving and concealing a motor vehicle that you were previously arraigned on. And it looks like you did have a PR bond, but it looks like you failed to appear. Do you remember why you didn't come to court, sir?
And I really don't. I was in the process of staying because I moved to a motel where I was working. And I just somehow slipped my mind. I'm not gonna lie, you guys, I just failed without accident. I'm not gonna lie to you.
Okay, well, you now have a new probable cause conference November 6th at 9 a.m. And then you have a new preliminary examination November 13th at 9 a.m. Let's see. Was he ever arraigned? Because it's not looking like it. Failure to appear arraignment, bench warrant from the magistrate is what I see from July 31st, 2023. So that means I would need the whole file to arraign him. He failed to appear for arraignment on June 8th, 2023. Let's see. Another arraignment was reset for the magistrate. I only see the magistrate's signatures. I don't think he was ever arraigned on this. Well, wait a minute, he had to have been. I see a note on the 15th. I was in Shiawassee County Jail. That was from the magistrate on the 15th of June 2023. So she did give him a bond, and then he was supposed to appear before Flores on the 22nd. So he was arraigned. He just failed to appear. So you'll appear before Flores on November 6th at 9 a.m. on that file, and then you'll have a preliminary examination before Judge Flores on the 13th. Okay, sir?
Yeah.
And then you have file number 23-02807. That's a controlled substance possession of meth and ecstasy. Same thing, you failed to appear on this one, but this one you clearly were not arraigned on that one. So I do have a felony complaint here. It alleges that on or about July 3rd, 2023 at 5513 Joshua Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of controlled substance possession of methamphetamine and ecstasy, and that you did knowingly or intentionally possess methamphetamine contrary L 333.74032BI. That's a felony with a maximum penalty of 10 years in prison and or $15,000 in fines. There's an habitual offender notice. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about February 6, 2007, he was convicted of the offense of identity theft in violation of MCL 445.65 in the 53rd Circuit Court for Sheboygan County, State of Michigan. And that on or about April 5th, 2021, he was convicted of the offense of home invasion, 3rd degree, excuse me, in violation of MCL 750.11084 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about April 5th, 2021, he was convicted of the offense of breaking and entering with the intent in violation of MCL 750.110, also in the 30th Circuit Court for Ingham County, State of Michigan. And therefore, the defendant is subject to the penalties provided by Michigan Compiled Law 769.12 that enhances your penalty to life if the primary offense has a penalty of 5 years or more. You are again charged in count 1 with controlled substance. The primary offense has a maximum penalty of 10 years. So you are facing life in that charge. Do you understand that, sir?
That's,
Okay, you have the right to be represented by an attorney. Ms. Straub from the Office of the Public Defender is going to represent you today for your arraignment only. You have the right to be represented by an attorney at each of your court appearances, and if you are questioned by law enforcement. If you can't afford to hire an attorney, you can make a request, again, to have the Public Defender's Office represent you at the expense of the public. You understand your right to counsel, sir?
ma'am.
You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to a jury trial. You are being charged with a felony, so you have the right to a preliminary examination, and you have the right to have that exam within 21 days of today's date, because today is the date that you are being arraigned. At the time of your exam, you have the right to have the prosecutor establish that they have sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the individual who committed the felony. You're currently scheduled to have a probable cause conference November 6th at 9 o'clock in the morning, and a preliminary examination November 13th at 9 o'clock in the morning. Which judge is holding that? Is that Flores?
Yes.
Okay, those are both before Judge Flores. You should have received the notice to appear. Is that correct, sir? Sir, did you get a notice to appear?
Oh, I didn't.
You didn't get any
Oh,
paper?
yeah, I did, I'm sorry, yes.
Oh, okay. Okay, so I think in seeing the date of this incident, it explains why you didn't come to court on your other matters. Because it looks like you were supposed to be in court around that time or later that time, but you had a warrant for the new felony, it looks like by then. Counsel, is he requesting the public defender to represent him?
Yes, Your Honor, he has.
Okay. The court's going to enter a not guilty plea on your behalf. You have the following rights. You have the right to the presumption of innocence, so you're innocent until proven guilty. You can, if this matter proceeds beyond a preliminary examination, take this matter to jury trial and have the prosecutor complete their burden of proving each element of the charge beyond a reasonable doubt. You have the right to be silent at trial and not have silence be used against you, the right to subpoena witnesses to testify on your behalf, and the right to question or cross-examine any witness called to testify against you. You also have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. What's your address, sir?
17 West John Road, Nancy, Michigan, 48910.
Are you currently employed?
Yeah.
You said yes, where?
Yes, ma'am, I'm at the Super Inn motel here on the south side.
What do you do there?
I do maintenance for them.
Okay. Are you currently on probation and any other files than the one I just mentioned, or on parole? Or on bond, that is, I should say. Are you on probation, parole, or on bond and any other matters?
So,
Hi, counsel, you can address bond.
Yes, Your Honor. As you are, I believe, aware, there are some prior offenses here for this particular for Mr. Morris. However, he does have extensive, almost lifelong ties to this community. His children and grandchildren all reside here. There is a bit of confidence that he would stay in the area for his upcoming court appointments. We do request a reasonable bond as you see fit, Your Honor.
Thank you. He has a history of failure to appear. We have a 2023 case where he's failed to appear multiple times. It's now being reset for November 6th, 2025. That's file number ending in 1581 FY. So bond in that matter will be set at 5,010%. Bond on the file number 23-02807. He's facing life if convicted, or up to life if convicted. And again, there's a history of failure to appear, plus a lifelong history of involvement with the criminal justice system. Let's see. Bond in that matter will also be set at 5,010%. The following bond conditions: you're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You will be required to undergo regular urinalysis testing. I'm ordering that you do that at least twice a month while out on bond. You're not to possess a firearm, ammunition, or weapon of any kind, and you must report to pretrial services within 48 hours of your release from custody. Do you have any questions for the court today?
I think you got the wrong file on the second one. I never
You
had a
can-
charge with meth.
You definitely do. I just arranged you on it.
I don't think you got the right person because it wasn't me.
What's your middle name, sir?
Dwayne, not Lee.
The file says Jerry Dwayne Morris.
well-
It's Jerry Dwayne Morris. It says on or about July 3rd, 2023. And so you can work with your attorney to flush that out, but it definitely has your information, your date of birth, all in this file, sir.
Good.
Do you have any other questions? Okay, you're all set. Let's see, so State of Michigan versus George McGill L 25-03286. And then it looks like I also have City of Lansing versus George McGill L 21L2629901. Counsel appearance, please.
Yes, Your Honor. Attorney Jessica Straub from the Ingham County Public Defender's Office on behalf of George McGill L. For purposes of arraignment.
Thank you. You're Mr. George Earl McGill L.
Yes.
Okay, Mr. Miguel L., I do have a felony complaint here that the allegations state that on or about October 28th, 2025 at 6200 South Pennsylvania Avenue, which is also known as the Meyer in Lansing, South Side, Ingham County, State of Michigan, that you allegedly possessed a controlled substance of cocaine, heroin, or other narcotic less than 25 grams, and that you did knowingly or intentionally possess less than 25 grams of the mixture containing the controlled substance cocaine, and that this is contrary to MCL 333.74032 AV. This is a felony with a maximum penalty of 4 years in prison and or $25,000 in fines. There's a habitual offender fourth offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about April 25th, 2012, he was convicted of the offense of stolen property, receiving, concealing $1,000 or more, but less than 20,000 in violation of MCL 750.5353A in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about July 2nd, 2003, he was convicted of the offense of uttering and publishing in violation of MCL 249 in the 30th Circuit for Eaton County, the 30th Circuit for Ingham County, that is, State of Michigan. And that on or about March 5th, 1992, he was convicted of the offense of larceny in a building in violation of MCL 750.3600 in the 56th Circuit Court for Eaton County, State of Michigan. Therefore, the defendant is subject to the penalties provided by MCL 769.12 that enhances the penalty to life if the primary offense has a penalty of 5 years or more, or 15 years or less if the primary offense has a penalty of under 5 years. Your primary offense does have a penalty of under 5 years, so your maximum sentence is enhanced to 15 years or less if convicted. Do you understand that, sir?
Yes.
Okay, you have the right to counsel, and Ms. Straub is representing you today for your arraignment only, but you do have the right to have an attorney represent you at all of your court dates and all of your court appearances, and if you are questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have the public defender's office appointed at no expense to you. Do you understand that?
Yes.
Okay, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. Your options are to plead guilty, plead not guilty, or stand mute. However, if you stand mute, the matter will continue all the way to a jury trial. You are being charged with a felony, so you have the right to have, a preliminary examination within 21 days of today's date, which is the date you're being arraigned, unless you waive that timeline or the court finds good cause to go beyond the 21 days. At the time of your examination, you have the right to have the prosecutor establish that they have sufficient probable cause that a felony was committed, and then enough probable cause sufficient to charge you as the individual who committed that felony. It says here that you're currently scheduled for probable cause conference November 7th at 8:30 and preliminary examination November 14th at 9 a.m. I believe this is before me. Is that accurate? Yes.
Yes.
It will be before me. You must appear in person for preliminary examination. You can appear via Zoom or in
Judge,
person.
it's Buchanan.
Okay, it was switched to Buchanan. I think no, they addressed something to me on here. Let's see. Okay, so you're appealing before Judge Buchanan, not me, okay? But your notice should tell you, your notice to appear that you should have received will tell you who to appear before. Did you receive a notice to appear, sir?
Yes, I think,
Okay, yes, and I see you have a yellow form, so that's definitely not my courtroom. So it's for Judge Buchanan, correct?
yes, it say Stacia J. Buchanan.
Okay. Very good. Okay, so again, you have the right to hold that preliminary examination unless you waive the timeline or the court finds good cause to go beyond that timeline. You also have the right to take this matter to jury trial and require the prosecutor prove your guilt by proving beyond a reasonable doubt each element of the charge being brought against you. You can maintain silence at trial and it cannot be used against you. You have the right to cross-examine and question any of the witnesses called to testify against you, and the right to subpoena witnesses to testify on your behalf. Do you have any questions about those rights?
No.
He is requesting the public defender.
Yes, Your Honor,
Yes.
he has.
Sir, are you currently on probation or on parole?
No,
And so we're entering a not guilty plea on your behalf. You don't have any other criminal matters pending, or do you?
no,
What's your address?
430 North Larch.
Counsel, you can address bond.
Yes, Your Honor. Mr. Miguel L. has represented or made representations that he does have some prior offenses, some of which are assaultive. However, he does have a wife and has lived in the area for 3 years, so he does have some familial ties to the area, providing a bit of confidence that he will be in the area and be able to attend his upcoming conference and preliminary examination dates. We do request a reasonable bond as you see fit, Your Honor.
Thank you. Mr. Miguel L., it notes here in the bond, pretrial services bond recommendation report, that you have an issue with appearing in court, sir.
I've always attended my court hearings. The only one that I couldn't attend was one down in Novi because I didn't have a way to get there.
It says here that the records indicate that you do have 2 or more prior qualifying failure to appear, which would make you which we counted as a risk factor for a bond, for PR bond. Nonetheless, I also have another file for you here, and I think it's from a balance, a careless driving accident. And this one is from May 15th, 2021 at 7:19 in the morning, allegedly at South MLK Boulevard at or near Mount Hope. It claims that you received a citation for careless driving causing an accident. You never actually appeared in court. There was a default judgment entered. And so you owe $366 on that. How do you intend to make payments on that, sir?
Well, I have an interview to give me a job, and hopefully I can get out of here and still attend the interview on Monday, and I'll be working and I'll be able to pay my fines.
Okay, so I'm going to refer this to collections, and you need to report by Monday to collections so that you can get on a payment plan, okay?
All right, thank you.
If you don't do that, then you'll end up with a bench warrant for that, okay?
Okay.
As to the controlled substance file, the bond is set at 1,000 personal recognizance. You're not to use, purchase, or possess drugs or alcohol while you're on bond. You're not to travel outside of the state without prior approval of the court. You need to report to pretrial services within 48 hours of your release. I am going to order that you undergo your analysis testing 1 time per month. Do you understand that?
Yes.
While on bond. And then, of course, you need to appear for all of your court dates. Do you have any questions about your bond, sir?
No.
Okay, any additional matters for the record, counsel?
No, Your Honor, nothing further.
Okay, you're all set, sir.
Thank you.
Thank you. The state of Michigan versus Juanito Dwayne Webb. 25-03290. Appearance, please.
Yes, Your Honor. Attorney Jessica Straub from the Ingham County Public Defender's Office on behalf of Mr. Webb for purposes of arraignment.
Thank you. You're Juanito Webb.
Yes, ma'am.
Okay, Mr. Webb, I do have a misdemeanor complaint here that alleges that on or about October 28th at the area of 1213, you don't have to worry, your hair looks fine, sir. Okay?
Yes.
Yeah.
Oh, thank
You've
you.
probably touched your hair 10 times since you've been up here. But you need to focus on these charges so you don't miss anything, okay? Okay.
Yes, ma'am.
Again, count one alleges attempted police officer assaulting, resisting, or obstructing in that on or about October 28th, 2025 at 1213 Center Street, Lansing, Michigan. You did attempt to commit the following listed offense and in the attempt did act towards the commission of that offense, but failed in the perpetuation or was prevented in the execution thereof, and that this was contrary to MCL 750.92. That is police officer assaulting, resisting, or obstructing. It said you did allegedly assault, batter, wound, resist, obstruct, oppose, or endanger Officer Jeff Kurtz, a police officer of the Lansing Police Department, that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D. And that's a misdemeanor. Maximum penalty is 1 year in jail and or $1,000 in fines. Upon conviction of attempted felony, the court shall order law enforcement to collect DNA identification profiling samples. Let's see. It also has a count two trespass alleging that on or about October 28th, 2025 at 1213 Center Street, Lansing, Michigan, that you did enter or remain without lawful authority on fenced or posted farm property of Alan Hooper without the consent of the owner, his or her lessee or agent, and that this was contrary to MCL 750.552. Count two is a misdemeanor and the maximum penalty is 30 days in jail and or $250 in fines. You understand the charge or charges and the maximum penalty, sir? I'm not asking you if you agree with the charges. I just want to know, do you understand what you're being charged with?
Yeah, yes, ma'am.
Okay, so you have the right to an attorney. Ms. Straub is representing you from the Office of the Public Defender, and this is only for the purpose of your arraignment today. But you have the right to have an attorney at all of your court dates and the right to have an attorney represent you if you're questioned by a police officer. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. You understand your right to counsel, sir? Okay, you have the right to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to maintain your innocence, and plead not guilty, or you can plead guilty, or you can stand mute. If you stand mute, the matter will go all the way to a jury trial. You have the right to the presumption of innocence and the right to require the prosecutor to prove your guilt by proving each element of each of the charges being brought against you beyond a reasonable doubt. You have the right to question any witness called to testify against you at your trial. You have the right to subpoena witnesses that would testify and present defenses on your behalf. And then you also have the right to maintain your silence and not have silence be used against you. Do you have any questions about those rights, sir?
No, ma'am.
Okay, you're currently scheduled for a pre-trial before, what judge is this before?
It's before you.
Okay, you got a pre-trial before me, November 10th at 10:30. Now you should have received a notice to appear and Zoom instructions. Did you get those, sir?
Yes, ma'am.
Okay. Are you currently on probation or on parole?
Oh, thank God.
Okay. Okay, you don't have any other court dates pending? Nothing else pending, sir?
No, ma'am.
Are you employed?
I wish I was. I'm not right now at my current status.
Okay. Is he requesting the public defender to represent him, counsel?
Yes, Your Honor, he is.
Yeah, the court will enter a plea of not guilty on your behalf. Do you have an address, sir?
I kind of do. I kind of don't. I kind of flounder around here. There's one of the reasons, the big misunderstanding why I'm here, but
Well, I don't want you to get into any elements that could be used against you or any statements or facts of that. I just asked, did you have an address? Because I did read the affidavit of probable cause, and then it does say that on your complaint, the address is unknown. So do you have an address that you can give at this
yeah,
time?
it was 520 Everett Drive. It's here in Lansing. I've stayed there before. It's one of my friends' own. He's a really nice old man. Let me show them
Okay.
for.
So that's where you would like your mail to go?
Oh yes, ma'am. Yeah. Yeah, that's where I have my social security mail too. I
Okay,
was here in Michigan.
give me that address again, sir.
It should be 520 Everett.
520 Everett?
Yes.
Okay. Do you have a phone number?
If I still have my phone, yes. I had a phone, some shoes. I don't know what happened to that. And a backpack full of stuff. And a bike, electronic bike. It's 517 356 2066. And there's no political agenda behind the electronic bike. It just gets me to point A and B, and I'm great. I worked for that. You know, I waited a while to buy one, and then I just was like, I'll take that one. I gotta
No
use it.
worries.
And
Okay.
it's still at the previous spot where this one full incident, quote unquote,
Okay, well,
happened.
I'm gonna stop you. I'm gonna stop you before you say anything else that could even place you at the location of the address. Counsel, you can address bond.
Yes, Your Honor. I would like to bring to the court's attention that Mr. Webb does have some previous assaultive offenses on his record. He has, however, he has made representations that he has always attended his court proceedings and has not missed any. He did make reference of absconding a very long time ago, but since has attended all of his required appointments. We do request a reasonable bond on his behalf as you see fit, Your Honor.
Bond in this matter is set at 500 personal recognizance. The following bond conditions will go into place. You are not to be at the address of 1213 Center Street. You're not to have contact directly or indirectly with Jeff Kurtz. You're not to engage in any assaultive or threatening behavior. You must report to all of your court dates. You also are not to have contact directly or indirectly with Alan Hooper. Do you understand that?
I don't know who that is, but I have no problem having no contact with any of the people that you mentioned.
Very good. Very good. Okay, and then you're not to travel outside the state without prior approval of the court, and you make sure you come back for all of your court dates, okay?
Yes, ma'am. Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record?
No, ma'am. Oh.
Okay, you're all set. Thank you. Give me just a moment, please. Oh, that wasn't for you. You're all set. I was talking to my staff. You're all set, sir.
All right, cool.
I'll be
Thank
ready.
you.
Okay, let me just see who this was in the waiting room. Who was on the iPhone?
It's Lakia Leak. She's for the LT hearing. She needs to actually go down to Judge Ward's, well, log into Judge Ward's.
Okay. Ms. Leek, we need you to log into Judge Ward's courtroom. We have to give you the information to log in, okay?
I have it whenever she's ready. I can't tell if she's ready or not.
Yeah, you're muted, so we don't know if you're ready, ma'am.
Okay, sorry, I was trying to pull up my notepad.
It's 934-285-9288.
Okay, so you said 984-285-9288.
934, and then everything else is correct.
Ugh, why is this not working? Okay, so 934-285-9288.
Yes.
Okay. So
Thank
I'll
you.
log off and then log into
And
that.
then log in with that number, yes.
Okay,
Thank you.
thanks.
Okay, let's see. State of Michigan versus Caleb Knopf, 25-03289 FY. Appearance, please.
Good afternoon, Your Honor. Attorney Jessica Straub from the Ingham County Public Defender's Office on behalf of Mr. Knopf for purposes of arraignment.
You're Caleb Knopf? Are you Caleb Knopf?
Yes, ma'am.
Okay, I have a felony complaint here. And the allegations of that on or about October 28th, 2025, that you in count one committed the act of controlled substance possession of methamphetamine or ecstasy, and that you did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032BI. That's a felony with a maximum penalty of 10 years in prison and or $15,000 in fines. Count two is weapons, dangerous weapon, miscellaneous, alleging also on October 28th, 2025 at 321 North Butler Boulevard, Lansing, Michigan, that you did possess metallic knuckles contrary to MCL 750.224. That's a felony. Maximum penalty is 5 years in prison or $2,500 in fines. Mandatory forfeiture of weapon or device is required under the law. Count three, a police officer assaulting, resisting, obstructing, alleges that on or about October 28th at 321 North Butler Boulevard, Lansing, Michigan, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Tyler Stover, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D. That's a felony with the maximum penalty of 2 years and or $2,000 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement or under the law for another violation violation arising from the same transaction. There is a habitual offender fourth offense notice indicating that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about October 14th, 2025, he was convicted of the offense of felonious assault. That would be only 2 weeks ago, in violation of MCL 750.83 in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about October 14, 2025, he was convicted of the offense of weapons, felony firearm in violation of MCL 750.227B-A in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about March 22nd, 2021, he was convicted of the offense of felony firearm in violation of MCL 750.227B-I in the 29th Circuit Court for Clinton County in the state of Michigan, and therefore the defendant is subject to the penalties provided by MCL 769.12. Life if the maximum penalty have a life if the primary offense has a maximum penalty of 5 years or more, or 15 years or less if the primary offense has a maximum penalty under 5 years. You are facing in the maximum primary offense here, controlled substance, 10 years. So that would enhance your maximum sentence to life if convicted. Do you understand the charges and the maximum penalty, sir?
Yeah.
You have the right to counsel. Ms. Straub is going to represent you to be arraigned. You have the right to have an attorney represent you at all of your court appearances and if questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to jury trial. You have the right to preliminary examination. You have the right to have the exam within 21 days of today's date, unless you waive the timeline or the court finds good cause to go beyond the 21 days. You have the right to require the prosecutor establish sufficient probable cause that the felonies were committed and then sufficient probable cause to charge you as the individual who have allegedly committed those felonies. You're scheduled for a probable cause conference. Is this before me, Ms. Nash?
Yes.
Okay, your probable cause conference before me on November 7th at 9 a.m. Preliminary examination before me in person at the court on November 14th at 9 a.m. You should have received notice to appear. Did you get that, sir?
Yes, ma'am.
Okay. You have the right to counsel. Again, if you can't afford to hire one can be appointed at no expense to you. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to have the prosecutor prove first each element of the charges being brought against you beyond a reasonable doubt at trial before you are found to be guilty. You have the right to question or cross-examine any witness that they call to testify against you, the right to subpoena witnesses to testify on your behalf and present evidence that you believe show a defense to these charges, and the right to maintain silence at trial and not have silence be used against you. Do you have any questions about those rights?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
Are you on bond for anything else?
Yes, ma'am.
What is that?
I want to say, I think it's felonious assault.
Out of 56A District Court?
Yeah, Eaton County.
Okay, but you were convicted of something 2 weeks ago?
Oh, no.
Hmm. Hmm. Did you plead guilty in
Oh,
30th Circuit to something recently?
nope. I'm still going through the court process.
Hmm. Maybe they put the, let's see here. They must have I think they put the wrong date. But it should have been 2015. It shouldn't have been 2025. That's what it is. Under the habitual offender notice. I see the previous convictions from 2025. Okay. I mean, from 2015. They put 2025 in the complaint, so that'll need to be changed. But nonetheless, okay. What you are currently on bond. Are you employed?
No,
How do you support yourself?
just live with my mom and looking for a
You
job.
said you say you do what?
So I just live with my mom right now. I've been looking for a job.
Hey, counsel, you can address bond.
Yes, Your Honor. Mr. Knopf has made representations that he does have a criminal history, and some of those offenses are similar to those being charged currently. He does have family here. He has been in the area since 2011 and has established some ties to the community. So there's a bit of confidence that he will be in the area and able to attend his court proceedings. We do request on his behalf bond, a reasonable bond as you see fit, Your Honor.
Okay, I do have a bond report here. Obviously, in this case, the defendant is being charged with a controlled substance, possession of methamphetamine, weapons, and then police officer assaulting, resisting, obstructing. He's being charged as a habitual offender, fourth offense, fourth offender, and he would be facing up to life if convicted of these. He's currently out on bond on another matter, which would make personal recognizance bond not appropriate. It says here that the defendant has pending matters in the 56A District Court 25-25098, which is assault with a dangerous weapon, that being a felonious assault. And then also police officer assaulting, resisting, obstructing. There's also a malicious destruction of building that's pending in 25-25026 SM. The defendant had some convictions from 2021 for weapons, firearm possession. And in 2018 for controlled substance, maintaining a drug house. There was a conviction. And then it looks like 2015 there was a felony firearm and an assault with a dangerous weapon conviction. And so it looks like the last 10 years he's been cycling in and out of the court, and it does indicate the defendant has 2 or more qualifying failure to appears in court. So he has a flight risk. He also presents a danger to the public safety. Again, personal recognizance is not appropriate. Bond and file number 25-03289 will be set in the amount of 10,000 cash surety with GPS tether. There'll be 24-hour house arrest if bond is posted. Do you understand that?
Yeah,
You're not to possess any drugs or weapons of any kind while you're out on bond. You're not to travel outside the state. You need to report to pretrial services. Do you understand that?
yeah,
I have here 56A District Court bond violation that you will be remanded to their court for, so they can address you on the bond violation before their court. Okay?
yeah.
Any additional matters for the record, counsel?
No, Your Honor, nothing further.
You're all set, sir.
Look,
State of Michigan versus Brittany Staley, 25-03288. Parents, please.
Yes, Your Honor. Attorney Justice Straub from the Ingham County Public Defender's Office on behalf of Ms. Brittany Staley for purposes of arraignment.
And you are Miss Brittany Ann Staley?
Yes.
Okay, Ms. Staley, I have a felony complaint here that you're being charged with in count 1 of police officer fleeing 3rd degree under the vehicle code, alleging that on or about October 28th at 321 North Butler Boulevard, Lansing, Michigan, that you did, being the driver of a motor vehicle to whom was given a visual or audible hand signal, voice, emergency light, or siren by Andrew Armstrong and or Tyler Stover, police officers who were in uniform, and the officer's vehicle was identified as a official Lansing Police Department vehicle acting in the lawful performance of his or her duty, directing the defendant to bring her motor vehicle to a stop, did willfully fail to obey that direction by attempting to flee or elude the officer and increasing the speed of the motor vehicle, and the violation resulted in a collision or accident, contrary to Michigan Compiled Law 257.602A3. That's a felony. The maximum sentence is 5 years in prison and or $5,000 in fines, and the Secretary of State is to suspend your driver's license. There's a count 2, malicious destruction of fire or police property, and that on or about October 28th, 2025 at 321 North Butler Boulevard, you did allegedly, willfully, and maliciously destroy or injure the personal property of that being a police vehicle belonging to or possessed by Lansing Police Department, and this was contrary to MCL 750.377B. That is also the same count in count 3, that is. Both counts 2 and count 3 are misdemeanors, and the maximum penalty are 4 years and or $5,000 in fines. Counts 4 and 5 and 6 are police officer assaulting, resisting, and obstructing an officer, alleging that on or about October 28th at 321 North Butler Boulevard, Lansing, Michigan, that you did allegedly assault, batter, wound, resist, obstruct, or oppose or endanger in count 4, Officer Tyler Stover, in count 5, and Officer Alexandra Zilowinski, and in count 6, Officer Andrew Armstrong, each of them officers of the Lansing Police Department that the defendant knew or had reason to know were performing their duties contrary to MCL 750.81D1. Each count 4, 5, and 6 are felonies. Each count is a maximum penalty of 2 years in prison and or $2,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 7 is reckless driving, alleging that on or about October 28th at 321 North Butler Boulevard, that you did operate a vehicle upon a highway, that being Butler Road, in a willful or wanton disregard for the safety of persons or property, and that this was contrary to the Michigan Compiled Law 257.626. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. There's an habitual offender 4th offense notice. It states that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about May 5th, 2023, she was convicted of the offense of attempted uttering and publishing in violation of MCL 750. What happens to the defendant?
Ms. Staley, please stand up.
I'm sorry.
Thank you.
What do you think? This is story time?
No, I'm sorry.
Again, there's a habitual offender notice. It says that the defendant was previously convicted of attempted uttering and publishing in violation of MCL 750.249A in the 44th Circuit Court for Brighton in the state of Michigan. And that on or about October 24th, 2019, she was convicted of possession of methamphetamine in violation of MCL 333.74032BI in the 56th Circuit Court for Eaton County, State of Michigan. And that on or about November 29th, 2018, she was convicted of the offense of possession of methamphetamine in violation of MCL 333.74032BI in the 56th Circuit Court for Eaton County, State of Michigan, and therefore the defendant is subject to the enhanced penalties provided by MCL 769.12 that would enhance your maximum penalty to life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. Your primary offense is, again, police officer fleeing third degree. The maximum penalty is 5 years. So you are facing up to life in prison if convicted. Do you understand that? I didn't hear a response.
Yes.
Okay, you have the right to counsel. Ms. Schwab is representing you today for your arraignment, but you do have the right to have an attorney represent you at all of your future court dates and the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at no expense to you. You understand your right to counsel, correct?
Yes.
Okay, you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to trial. You are being charged with with a felony, so you have the right to have a preliminary examination, and you have the right to have that exam within 21 days of today's date, unless you waive that timeline or the court finds good cause to go beyond the 21 days. You're currently scheduled for probable cause conference November 7th at 9 a.m. and preliminary examination November 14th at 9 a.m. Did you receive notices to appear, ma'am?
Yes, I did.
Okay, I believe that they're scheduled before me. Is that correct?
Correct.
Yes.
Okay. You have the right to have your preliminary examination. And you have the right to have the prosecutor establish that they have sufficient probable cause that the felonies that you're being charged with were actually committed, and then sufficient probable cause to charge you as the person who committed those felonies. Do you understand those rights?
Yes.
You have the right to take this matter to trial and maintain your innocence until proven guilty, and to require the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, and question in court any witness called to testify against you, the right to subpoena witnesses to testify on your behalf, and the right to maintain silence and not have silence be used against you. You also have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Is she requesting the public defender to represent her?
Yes, Your Honor, she is.
Okay. Ma'am, are you currently on probation or on parole?
No.
Do you have any other court cases pending at this time?
No.
The court's going to enter a plea of not guilty on your behalf. What's your home address?
Yes.
What is your home address?
Oh, 5334 West Mount Hope Highway, Lansing, Michigan, 48917.
What's your phone number?
517-488-7786.
Are you employed?
No.
How do you support yourself?
Friends and family right now.
Counsel, you can address bond.
Yes, Your Honor. Ms. Staley has made representations that she does have extensive ties to the community. She has lived here most of her life. Her family also resides in the Lansing area. Relative to the flight risk component, that does present a little bit of confidence that she will remain within the area. Relative to the danger piece, she does have some prior offenses, as she's made representations rather to that fact, most of which are possession. She also made representations that she does not believe she has any failures to appear. With that being said, we do request a reasonable bond on her behalf as you would see fit, Your Honor.
Thank you. I do see, as indicated in the bond report, that there's not a history of failure to appear. I do see, however, since 2017, she's been through the criminal justice system at least 11 times since 2017. So there's a history, but I agree that it looks like the broader nature of the history does include underlying substance abuse issue. I'm gonna grant a personal recognizance bond in the amount of 5,000 personal recognizance. There will be GPS tether requirement, and you will be testing 2 times a month. Do you understand that?
Yes, ma'am. Thank you.
You need to report to all of your court dates. You're not to travel outside the state unless you get approval from the court in advance. You're not to use, purchase, or possess alcohol, drugs, or marijuana. You're not to use, purchase, or possess firearm, ammunition, or weapon of any kind. You're not to engage in any assaultive or threatening behavior. Do you have any questions about your bond?
Oh, thank you. You said it's personal recognizance, but you have to have the tether thing.
Correct.
Okay, thank you.
Thank you. You're all set.
Thank you, Your Honor.
Thank you. Have a good one.
You too.
Thank you, Ms. Strong. Who do we have in the courtroom? Thank you, Mr. Lee.
Thank you,
Ms.
Your Honor.
Strong.
Have a good day.
Oh, Kathy's with
Thank you,
probation.
Your Honor.
Yeah, I forgot.
Yeah.
We just have, what was your last name? Sparks. Kathy Sparks. She's the new probation deputy clerk. She's just
I
observing.
was making sure I didn't have any
No.
LT stuff. Got
We
it.
do have a
Okay.
question.